Splitting assets in divorce doesn't follow a one-size-fits-all approach. And in Australia, settlements are based on what is just and equitable, not necessarily equal. And today we're going to talk about 8 common ways people split their assets for property settlement. And hopefully you can get an idea for the way you would like to approach your divorce property settlement. Welcome, Mum.
Hello, Laura. Hi, everyone.
Now, before we get started, this is a super important note to say that Mum is not your lawyer. I'm not a lawyer. And all of this is just a discussion about property settlement. If you need to make these kind of decisions, please go and see a lawyer before you do anything, because this may not be suitable for you. So let's get to jingle and get started.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
All right, Mum. So property settlement, just the word makes me want to vomit. And I'm sure it brings people into sweats. But I know there are a lot of people out there, and you know, because you talk to them as well, who don't know that there are a complete multitude of options when it comes to how you divvy up the assets based on your particular situation.
Yeah, that's right. That's right. Some people, they think percentage is, and that is the hard thing, but it's how that percentage is made up is what people have to consider. And that's where the variety of ways comes in.
That's right. So let's talk about the classic one that everybody thinks is the thing, and that is the percentage split. Just a classic, let's just split it. A lot of people think it's just 50-50. That's how you split it.
Yeah, and that might be the case for some people. There's a lot to think about when you apply the Family Law Act to property division, particularly after June the 10th of 2025 when the new changes come in. And so the percentage, reaching the percentage is half the battle, okay? Once you're sure about that, you then can start looking at the mechanisms, which is what we're talking about today, of how you achieve that split.
Now, we're not going into it today, but it is important. If this is the first episode you've ever listened to about property settlement, you can jump on our website, thedivorcecourse.com.au, and go to the free resources section and go to the podcast library, and you can type in property settlement in the search bar, and it'll bring all of our episodes up that talk about property settlement, where we discuss about the Family Law Act and what they look at to determine what that percentage split is, because that is not what we're talking about today.
No, but I would like to remind everyone to check your deadlines, your time limits, if you've been married and divorced, or if you're de facto. So go and get some legal advice on that, and don't let your time frame run out, because if you try to get into the court after a year or 2 years, depending on your circumstances, the court may not agree to do any property settlement and everything stays as it is. So super important.
Okay, Mum. So you've just said that, and there'll be people going, time limit? What time limit? Oh, my God.
Sorry.
So can you tell me if they're divorced, officially have the paperwork to say they are unmarried, what's their time limit?
1 year from when the divorce becomes final.
If they're not divorced, they're still married, but they're separated, do they have a time limit yet?
No, not until they get divorced.
Okay, and if they're de facto and they're separated, what's their time limit?
It's 2 years from the date of separation. But just be careful, because there's arguments about when it was a separation and when it wasn't.
Can separation date start while you're still living together?
Sometimes it can, yes.
So listening to that, so don't run off in a panic, go and see a lawyer after you've listened to this episode, so that you know that you're within the time limit, so you can go to the court if you need to. All right, so there's the classic way is the percentage split. Now, here are some other ways that people manipulate that so that they can get the percentage in the way that they want it laid out to them. And this is one of the other scenarios, that you take the house, I'll take the super.
Yes, that is one way of doing it. So once you've reached your percentage, then what we do as lawyers is we tally up what everything is, including the equity in the house and cars and super and everything. We reach a number. Then we apply the percentages to that number, and I make 2 columns, one for one person, one for the other person. And then I put in their columns the things they're going to keep, and keep subtracting it from their share.
So once they've figured out how much the property pool is and how much the percentage it is, then you figure out how you're going to divvy up the pool.
That's right. You work out what your share is going to be. So say if it was 50-50, and that's just a figure out of the air. I'm not saying it's 50-50 for everyone, but say it was 50-50, then, and you definitely wanted to keep the house, well, that would come off your 50%, the equity in the house, right? So you take if you've got $1 million house, it's not necessarily $1 million off your share. If you've got a mortgage, and if you've got, say, a $700,000 mortgage, then it's only $300,000 on your side. And so usually you plug in the first things you put in each side are the things that probably were agreed on really early on and the big ticket items. Okay.
So can I ask, Mum, with this you take the house, I'll take the super.
Yeah.
What kind of cautions do you give to anyone who thinks that's a good way to go?
It's a worrying plan, and a registrar may not make that order if you try to do it by consent order. And the problem with all the super to one and the house to the other is that the person with the house, if that's mostly all they get, they may not have enough income to manage the house. If things break down and so forth. And then when they reach retirement age, they've only got the house, so they have to move out because that's where all their money is. On the other hand, a person with superannuation, they don't have enough money usually in cash to buy another house. Usually, though, if they've got a big superannuation, they've got a higher wage and they may be able to borrow. So I have seen circumstances where one person gets the house and nothing else, pretty well nothing else, and the other person gets the super and pretty well nothing else. But both of them have to be quite confident that they can manage on what they get. And a court will look very carefully at that split because they generally would think someone should get some cash and and also super, so that it's a fair balance for both parties. Okay.
I think it's important to put this out there that there is the option of a BFA, a binding financial agreement, or it's not binding, but a financial agreement. We've done a great episode called Consent Orders versus BFA. What's good for you? And I guess maybe as your mum, you're saying that the court may have trouble putting that through. One of the ways you could get that happening is not going through the court at all and having a financial agreement instead.
Yeah. If you both agree, the court generally is happy enough to make those orders as long as they can assess that it's the right thing to do. So you might have to do a letter explaining how one person really needs to keep the house and why the other person is happy just to keep super.
And if you're interested in really wanting to keep the house, we have 2 good episodes called I Really, Really Want to Keep the House, and how Mum suggests there's some strategies there to keep it in property settlement. And the other one is out of the box ideas on keeping the house if you're not sure how to go about it. Now, Mum, number 3, another common way people deal with property settlement is they sell everything and just split the proceeds, put it all into cash.
Yes, and that's a really unusual way of doing it, but I have seen that happen. Where the problem lies with that, I think, if anyone's thinking about that, is that if you sell, say, your house, you've got agents' fees and everything, and you actually have less in your property pool than you would have had if someone had kept the house, if you know what I mean, because you're paying that money out. And you can't do it with super, of course. So, so that really doesn't, I think, satisfy most people going forward. And if you dig a little bit with people when they're thinking about things, one of them usually wants to keep the house. That's why we have those episodes. I really want to keep the house. And I think sometimes, there's a little bit of spite in that a person go, right, if we're splitting up, that's it. You're not getting the house. We're selling the lot. If that's happening to you, you don't have to do that. If you went to court and you could afford to keep the house and take over the mortgage and pay your ex out, the court would lean towards letting you keep the house. So don't feel you have to sell everything.
But I guess if neither of you or your ex can afford to pay for the house or buy the other person out, then you kind of have to
have to sell it, yes. And you don't want to really get it into your name and then have to sell it, because then you take it as a value that doesn't have agents' fees taken out, and then you sell it, it might sell for less, plus you've got to pay the agents' fees, and then you're sitting there going, oh, that was a silly thing to do. So what you need to, if you think you have to sell the house, which is different to selling everything, but if you think you have to sell the house and you've reached agreement, do it before you decide on dollar figures and so forth, do it before property settlement. So, well, as part of your property settlement while you're still together, so that each of you is going to carry some of the cost and some
Yes.
of the risk.
I've seen real estate agents say, oh, yes, like I could sell, like when I had my house valued, I had 4 real estate agents come along and I was trying to figure out who I was going to use. One of them was like, I can sell it for this much. And the other one was like, I can sell it for this much. And the difference in how much they said they could sell it for was massive. So you don't want to risk. And then what it actually sold for was completely different as well. So you don't want to risk saying, oh, yeah, I'll get the house, I'll sell it, and I'll keep the proceeds. If it's a massive drop all of a sudden, you really get ripped. But some people want a fresh start. We have a really good episode called Selling the House, and Mortgages in Divorce. If you want to look at those episodes, you can look for them in the show notes.
Yeah.
Number 4.
Can I just say something on the houses?
Yeah.
If you have renovations to finish and you have the ability to do those renovations, you may want to take the house on, and then you can do that work and then get the higher price. That's a thought.
That is a thought.
Yeah.
Number 4.
Okay.
One buys the other one out. One person keeps the home or another major asset, pays out their share, usually through refinancing, and that's good if you've got kids and you want to keep them in the same space. And you've got the ability to keep on a mortgage.
Yep.
Yeah.
So it depends on 2 things there, doesn't it? One thing is obviously the ability to take over the existing mortgage. Could you refinance that mortgage into your own name? Can you afford the payments? But the second element is, how much do you have to pay the other person to get them out, right? So if you had a house worth $800,000 and the liability was $600,000, right? The mortgage $600,000. You've got to be able to, if you're going to take that house, you've got to be able to cover the $600,000 mortgage, put it into your name, plus the other $200,000 has to be divided. And if you're going 50-50, you've got to borrow an extra $100,000 to buy your partner out of that $200,000 equity. And so people need to check and see what their capacity is. It's really hard if someone's been a stay-at-home mum and doesn't have a working record to be able to buy the house. And we talk about different ways there. But that way of doing it means the person who essentially gives up the house goes away with no mortgage attached to them and a small cash payment usually, okay? And the person who kept the house has a mortgage greater than it used to be when there were 2 of you paying it, but you keep the house. Right?
There is a catch with this option, though, is because unlike when you sell the house and divide it up, you're not selling the house. So how do you get an agreement on what the house is worth if you're keeping it?
You get your real estate agents with their wildly differing views in, and I've had it so many times, or you could have it formally valued with a proper valuer. They're very conservative by and large, but I've used the thing of getting 3 real estate agents to give an idea of what it's worth. And when they're wildly different, you add the 3 up and divide it by 3, and that's your average. You've got to get the buy-in of the other person, first of all, to let's agree this is the formula. Here's some agents, you pick them. So that sort of thing. But yeah, there is a bit of a kicker in it. And you're taking that house with potential liability if you sell it later on of the agent's fees. But the way the court deals with that is they say, I think this is their rationale, is that house may grow in value and it'll be you that gets that benefit. Yeah.
Okay. Right. Wow. My head's spinning already.
Oh, no, I'm trying to do it normally.
Right. But if you are interested in learning about selling the house during divorce or keeping the house during the divorce, go look in the show notes. We do have those really good episodes.
Yeah, and we talk about the personality types when it comes to that as well.
Yes. You've got to really make the right decision there because, and I'm just going to put it in here anyway, if you are going through family violence or domestic violence, call 1-800-RESPECT, and if this triggers you, call 1311 14 Lifeline. But you don't want to be in a house where your ex still feels like they own it too, or they somehow feel familiar enough with it that they know the quirks and can just drop by at the drop of a hat. So you do have to think about the personal as well as financial aspects of why you want to stay or go.
And they may be resentful because you're in the house. And in a bad case scenario, they may have wired the place, put surveillance in, bugged the place, have spare keys. So if you've got a creepy ex, maybe you don't want to be in that house anymore.
We're desperately trying to get this amazing guy on to help us talk about that kind of stuff, because he actually does that as a job for a charity, goes around and checks people's houses, checks people's cars. So we are going to get him on. It's just a matter of making sure our timing is the same. All right, let's get on to the fifth way that some people negotiate their property settlement is they trade assets. So cars for cash or shares for equity. Instead of selling everything, they kind of trade. So one keeps the car, one keeps the cash savings, or one gets a larger home, a larger investment. So can you talk me through how you come out with that idea?
Yeah.
How do you do it?
Well, the court does that a lot because their aim is to not shrink your asset pool, right? And every time you sell something, there may be costs associated with sale. So although we put a dollar value on things, you don't actually sell them. So with furniture, for instance, like you always hear me say, the court doesn't do furniture fights. I never do furniture fights, but there's systems and ideas that the court has. And one of them is like draw up two lists of the contents of the house, list A and list B. You do that, right? And then your ex gets to choose one of list A or list B. And that seems to work very well. And then what you have is everyone's got their stuff. Whatever it's worth, you don't even probably have to value it if you think you've got it roughly equal. And remembering that it's all secondhand anyway, because that's what you're dividing up, secondhand. So that's one of the ways the court does it. Sometimes a person will say, we've got two cars, but I need more money on my side. We'll swap cars over. Just trading off, I won't give you as much super, but you can have more of the house, that sort of thing. And remembering that superannuation, if you're under 60 or under 55, superannuation is a bit pie in the sky. And so you may be very focused on your immediate needs. I need somewhere to live. I need somewhere to have the kids. And you might be happy to settle for the house, but it won't be as if you end up with superannuation, like you're happy to settle for the house, but the person who's getting the superannuation, whatever it's valued at, it's not as valuable as a dollar today, because a dollar today you can do something with. A dollar, when it's, like I say, pie in the sky, is a bit of a distant thing. And so usually people who are taking superannuation get a kind of a discount, and you wouldn't put it in necessarily as a full settlement of their entitlement. Yes.
Yeah. Okay, well, that takes us on to number 6, and that's super splits. So I don't know why, but there's some annoying thing where some people think you just don't touch super at all and it's not even included. But one of the ways that people do deal with property settlement is they split their super. And it doesn't mean you get it in cash, though, that you can spend straight away.
Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section, where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist, along with the accompanying episodes of the podcast, will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today.
That takes us on to number 6, and that's super splits. So I don't know why, but there's some annoying thing where some people think you just don't touch super at all and it's not even included. But one of the ways that people do deal with property settlement is they split their super. And it doesn't mean you get it in cash, though, that you can spend straight away.
No, it doesn't. So yes, so some people might say, look, it's more fair we'll sell the house, we'll have some cash each, and we'll divide our supers between us, right? And if one's got much more superannuation than the other, then there needs to be a transfer of superannuation to the person who doesn't have as much. And the way the superannuation companies do that is that they will say, okay, if you've got given a proper warning, okay, all right, well, if we've got to give 100,000 over to this person from your superannuation, what we'll do is we will roll it over into a fund of their choice if we've got a court order telling us we have to. okay, and if you gave us 28 days notice. So you can split super, and it's not very tricky to do it. And it's usually these days an accepted thing to divide the super. Where I get on my high horse a bit is when people just want to equal the super. So if you've got 25,000 and they've got 75,000, if they give you 25,000, then you've got 50,000 each. But the reason they've got 75,000 probably is they've got a higher job or they haven't been home minding kids. And in a very short time, you're going to be behind again. And they do this sometimes after calculating a percentage overall, but then they don't apply the overall percentage to superannuation. They just apply it to the assets. So that's my current hobby horse, guys, equalizing super. But yeah, so people do that.
All right, number 7. I don't understand this, so you're really going to have to explain this.
All right, I'll try.
Offsetting debt. Sometimes one party takes on more joint debt, like a mortgage or a credit card, in exchange for a larger share of assets.
Yeah.
What do you mean by that?
So remembering I was talking about the house, right? Your imaginary $800,000 house with $600,000 debt. That debt probably is in joint names. If you take on that debt, the whole 600, then that's going to be, I guess, a contribution you're making to the other person. You're saying, look, you give me the house, but I'm going to take over your half of the debt there, and I'm going to borrow some more to pay you out.
Can we talk about credit card instead?
Okay.
All right. So imagine they've got a credit card debt of $100,000.
Wow. Yes.
Oh.
Okay. So credit card debt of $100,000, which is making your hair curl at the thought of this credit card debt. But you've got a good income and you can manage it. And if you take that debt on, that's a negative on your side of the ledger, and that might allow you to keep the house, or it might allow you to keep all of the stuff you want. So for the person who is half responsible for that debt, if it's joint names, you need to be sure that they actually refinance that money into another credit card or of their own, because if they don't pay it, the person that you owe the money to is going to come gunning for you if you're on that credit card.
Well, let's talk about this to make more sense. So say Susie, this random person, has a credit card debt with her husband of $100,000. Susie breaks up with John. They go their separate ways. And in the property settlement, Susie says, I'll take the $100,000 debt on.
Yes.
But if Susie doesn't sort it out and pay it off, John could be in trouble later down the track.
That's right. So sometimes you see an arrangement like this where they don't bother refinancing it or rolling it into another account. They just leave it in a credit card in joint names, and you are really exposed there. And so that's usually not a good idea.
How do you get your name off the debt then? You refinance it in their name.
They refinance it, and you need to know. And if you're listening to this and you're in the middle of doing any sort of orders that involve someone refinancing a debt or paying money in exchange for you giving them something, make sure that you have got good legal advice. It needs to show when it's going to happen, and usually it happens at the same time. You wouldn't sign the house over and then wait 3 months to see if they're going to get your name off the mortgage. So you make sure that happens, or the credit card thing, make sure that happens and you've got proof of it before you give them what they want. And also make sure you've got provision for if there's a failure, if they don't pay, there's an or else. So that's why you need to talk carefully to your lawyer, because what you think might look all right in consent orders might actually be lacking the consequences, might actually be lacking the timing, and actually may even be lacking the date by which this has to be done.
We have had a lot of people write in saying my ex isn't following our orders. What do I do? So there are those people out there dealing with that. So please don't end up being one of them. So like Mum says, we talk about it in the course. Think about who's doing it, when they're doing it, where they're doing it, why they're doing it, and what happens if they don't do it.
Yes.
So you can basically use debts as a way to say, I'll take this on if I can get a larger share of the assets.
Yeah, that's right. Okay. That's right.
Okay. And number 8 is leaving assets in the name they're already in and not doing anything.
Yeah. So that turns up occasionally in shorter relationships, or a relationship that maybe you separated earlier, divided all your property, got back together briefly, but you're pretty well running your own show financially. And sometimes when you work out a person's entitlement and you have a look down the ledger and you think, well, it's pretty close to what you've already got and pretty close to what they've already got. And you might think that you could just walk away then and go, well, see you, nice knowing you, but, off you go with no transfers. But there is a big risk of doing nothing.
All right, so we'll talk about the risks in a minute. But basically, Mum, you're saying that some people, if they're really simple, they've got a car each that are worth about the same. Maybe they had 2 houses, one was an investment property, and they're worth about the same. The mortgage is about the same. Their super's about the same or whatever, and they're just happy to just leave it as it is and walk away. That's doable.
Yeah.
But you're saying the risk is what?
The risk is that if you don't do it in a document, have a final consent order, even if all it says is informal language, but each keeps what they've got, then if someone suddenly comes into money in their time, before the time limit's up for settlement, then the person who didn't get the money could go to court and ask for a share of that money. So ever since that case of Farmer and Bramley, where the fellow won lotto 18 months post-separation and the wife got a share of it, we've all been nervous now. And my advice to nearly everybody is that you should really look at getting your consent orders, locking it in, even if there's nothing extra to be done. But an interesting point that you raised, Laura, there is an assumption that would be 50-50, but it might not be. You might have had a very short marriage, 4 years maybe, no kids. One person's brought in quite a lot and it's still in their name. The other person didn't have much, but it's still in their name. That still might be fair enough for a short relationship. So it doesn't have to be the 50-50.
If you've seen a lawyer and you know what you're entitled
to. Oh, my goodness, yes.
Yeah. But I've heard some pretty nasty tricks when it comes to property settlement in general. One of them was the lady said to me that they went to the bank and they had savings or whatever, and they got the bank to put half in his account and she kept the other half. And she thought that was their property settlement. And then they still hadn't got divorced, but they were obviously separated. And then 2 years later, he came back, had spent all that money and wanted more money. Yes. And there was not really much she could do about it, and then had to negotiate again. And I've heard of other people who have just gone, I'm just going to walk away. And same thing again, it kind of bites them in the butt, because then they're like, wait, I actually do need that money. I need something. And they have to go back to court.
Yeah, so it's not over until it's over. It's not over till you've got a financial agreement or you've got a sealed court order. Or if you're confident you'll be okay, some people just wait until the time limits are up and hope that nothing happens from there.
We are not recommending that.
We don't. No, we don't. No, it's a bit of a worry for people to separate and to just leave it go like that. Yeah.
So really, I think the whole point of today's episode was to just explore the multitude of ways that you can negotiate your property settlement. And I do think there is a stereotypical understanding that you just do 50-50 percentage split and equalize supers and all that sort of stuff. And it's not necessarily the case. And Mum, you must have seen and do see multitudes of consent orders for property.
Yep.
Are they all the same? Like, or is it just always completely different?
Look, there's so many moving parts, okay? And it depends what's in that family's property pool. And it might be like a timeshare somewhere has to be factored in, or there might be a caravan, or just lots of money in the bank, not much money in the bank. And after the 10th of June 2025, for once, this court is to look at what's happened to the money since separation. So that lady you were talking about, where all the money still came into the property pool, and the court sort of could have had a look at contributions, but she wouldn't get much recognition for it in those days. If you've got a situation where you've been really frugal and saved up post-separation and the other person hasn't, and blown it all, and then they come for a share, under the law that's coming in on the 10th of June, the Family Law Amendment Act 2024, you'll read that, then the court is going to take that into account, and it'll be like to your lady, okay, so what have you done with your share? Oh, I've saved it or I invested it, whatever. What have you done with your share, mate? Oh, well, I've done this. Well, they're going to go, well, you've had that. That's a premature distribution of assets. So that comes off your side of the ledger. And sometimes the courts, that they do have to start with deciding whether it's just and equitable to make any order at all. That is, do they make it any order that any piece of property goes to any other person as part of the property, as property settlement? And there are people who think that if you're not transferring anything to anybody, that the court really has no more work to do. But that is not really correct. The court can make an order to lock it in as to what happens, and the order to not transfer property between each other is still an order the court can make.
And it's drawing a line in the sand to say, it's over now, you're settled, there is no more. Because you would be a little bit nervous having it hang over your head. I know you say that there's the time limits, but people can still get special permission to get through those time limits and say, look, I'm destitute or I'm homeless now, I do need really money, and the court may consider it. So you're always going to have that in the back of your head, especially if you repartner and you buy a house with them, and then it turns into a giant nightmare.
It does. And people, they think that it's not worrying them, but I think it does worry them. I think it's always in the back of your mind. And sometimes you're thinking, well, it'll keep them happy if we don't have property settlement. I'm not going to push it. And then just as the deadline comes up, they file for property settlement anyway. And you've had like 2 years or a year of being a bit sick in the stomach about it. So there's something to be said for biting the bullet, having the discussion, getting it done. I know it's hard. I know it's really hard for people. And it's like a big knot you've got to try and untangle. You can get through it. You can.
First step is just determining what your property pool is and writing. If you're a spreadsheet person, then do a spreadsheet of all the things that are debt or not, the opposite of debt. What's the asset? Assets or debts?
Liabilities. Assets and liabilities.
Put it all in there and just list it all out. If you're not a spreadsheet person, I know everyone is going to laugh at this, but coming from a past primary school teacher, if you want to draw the car and cut it out and have the caravan and cut it out, have a line and go, that could be on that side and that could be on that side, and write their values in there. You just do what you do.
Yep, I use good notes and I handwrite because I get hives looking at spreadsheets sometimes. But
we do have a spreadsheet in our course.
Yes, someone was telling me yesterday they used it.
We help you determine your property pool, then we help you determine your contributions before, during and after, and your future needs, which we also have some great episodes on, so you can figure out what percentage it is, and then you can start having a little play with all these ways that people make their property settlements happen. Mum, I'd like to say to you thank you for doing that, because I do think some people don't explore all their options, and no offense to lawyers, but I do sometimes think they just go, this is how we've always done it and this is how you're going to do it. And I think it's good for you to know that you've got options on ways to move the assets around to get the percentage that you're entitled to.
Yeah, because every family is different, every couple's different, and we all, if you went into each other's homes, there'll be different foods they eat, different bedtimes, everything. So you apply it to your family and then explain it to your lawyers why it makes sense for you.
Yeah. So again, we've got great episodes in the property settlement option. Go to our website, thedivorcecourse.com.au, go to the free resources section and go to the podcast library, find any of the topics you're interested in, or download one of our mediation checklists, disclosure checklists, or before you go checklists. Thank you, Mum, for your time, and we'll see you next week.
Thank you, Laura. Bye-bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording